you're about to see isn't just another heated hearing. It's a sitting member of Congress discovering that the federal government secretly seized his private phone records and never told him.
Thank you very much. Thank you very
recognize
much.
the gentleman from Texas.
Thank the Chairman. Mr. Smith, how many members of Congress or the Senate did you subpoena phone toll records?
As I sit here right now, I do not recall a specific number.
Is this the complete list right here? Well, let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I've been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that established and opened the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now, that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco, and you briefed the AG and Deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, as we already talked about, my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and, frankly, anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we stated.
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jen Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking.
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. I yield back.
Gentleman yields back.
The gentleman have the opportunity to respond?
If the gentleman wants to respond, he can.
With respect to the last point, Judge Cannon's order specifically limited her finding to that proceeding. So there would be nothing improper about continuing to litigate the cases in Washington, D.C. And with respect to Florida, there was nothing improper about taking an appeal of that very decision.
This exchange between Congressman Chip Roy and Special Counsel Jack Smith just shattered any illusion that this investigation had clear limits. It started with a simple question. How many members of Congress or the Senate had their phone records subpoenaed? Jack Smith couldn't answer. That alone should stop everyone watching. Then Roy asked the question that changed the entire hearing. Am I on that list? Smith admitted that Roy's phone records were, in fact, subpoenaed, while trying to deflect responsibility by saying it happened before he officially became special counsel. But here's the part that matters. Roy didn't know. For 4 years, Roy told the committee he only found out a few weeks ago, not because the Department of Justice notified him, but because his staff uncovered an internal email by accident. When Roy contacted @NT, they confirmed it. His private phone records were quietly handed over to the DOJ back in May of 2022. No warning, no chance to object, no explanation, and Roy wasn't alone. He referenced fellow Congressman Scott Perry, whose phone was physically seized by federal agents in front of his family. That's not routine law enforcement, that's intimidation. Roy framed the issue clearly. This isn't about politics, it's about the separation of powers. Members of Congress have constitutional protections, not for themselves, but to protect the people they represent. And those protections were bypassed entirely. Then Roy went further. He pointed to internal DOJ memos signed by Attorney General Merrick Garland that authorized sweeping investigations months before Jack Smith was ever appointed. This wasn't rogue behavior. This was policy. The investigation, Roy explained, originally focused on alternate electors, something that has historical precedent, including the 1960 presidential election in Hawaii. But then the scope exploded. Suddenly, it wasn't just about electors. It was about President Trump and anyone who had ever worked with him. Lawyers, advisors, political allies, private citizens. Roy highlighted the case of election attorney Cleta Mitchell, who filed a formal election challenge in Georgia backed by affidavits, expert reports, and over 1,000 pages of evidence. Roy asked a question that should have ended the discussion immediately. Is filing an election challenge a crime? Jack Smith answered. So Roy followed up. Then why were her phone records monitored years later, long after the election was certified? Smith had no real answer. Roy then listed name after name: Jenna Ellis, Sidney Powell, Bill Stepien, all targeted years after the 2020 election. Roy made the point crystal clear. Being wrong is not a crime. Losing a case is not a crime. Filing a legal challenge is not a crime. But surveillance without limits is. Then came the scale of the operation. Roy revealed that more than 400 conservative organizations and individuals had their records obtained, including the RNC, Trump campaign accounts, major conservative groups, and grassroots activists across the country. This wasn't narrow. This was a dragnet. And Roy asked the question that still hasn't been answered. Are there any limits on the power of a special counsel? Because if federal prosecutors can secretly obtain records years later, without charges, without notice, without accountability, then the rule of law becomes a political weapon. Roy ended with one final bombshell. A federal judge ruled that Jack Smith's appointment violated the Constitution's appointments clause. Yet Smith continued signing court filings anyway until resigning in January of 2025. Another judge has since warned that prosecutors who do that could face disciplinary action or even disbarment. That's not partisanship, that's prosecutorial overreach. Chip Roy yielded back, but the damage was done. Because if this can happen to a sitting member of Congress, it can happen to anyone. And that's the question Americans are now left with: who's watching the government when the government is watching everyone else?